Hi, Attorney Steve Vonner, civil litigation attorney. We are talking in this exciting episode about the California right of publicity law. So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, let's back this puppy up and let's get going. Okay, right of publicity law, this is a growing thing now with the internet. This often arises in very competitive situations. This arises in commercial situations where companies want to use the name, image, and likeness of another person to market their advertising, their goods, their services. They're trying to make money off somebody else. This could involve like a model release, failure to obtain a model release, lots of different things, all kinds of things that pop up, a wide body of case law. But let's talk about it. This is going to be specific to California. This is going to be some general information about this really what I find to be very interesting topic. So let's talk about this. Okay, so the right of publicity, this is basically, California with Hollywood, all the stars, you got athletes everywhere, lots of personalities, celebrities, all kinds of things. But it doesn't have to be a celebrity that we're talking about. It could be just somebody, maybe it's a cute kid or something. Somebody says, wow, that's a really cute kid. Let's put him on our box of cereal and start selling it. It's the cutest kid in the world. Or let's put this this person I saw at the beach, a bikini model. Let's put him in our advertisements, and just it looks really good, and nobody knows who the person is. I don't know. You don't know. So, but these situations can arise where somebody's using your name, image, likeness. But there's lots of other things. It could be your nickname. It could be your voice, a voiceover. So we've had cases like that. But we're going to talk about the two different elements in California. You have what we refer to as the common law, and we have the statutory right of publicity. That's under section 3344. 3344 of your civil code. Jot that down for your extra point. Civil code 3344. Now, so when you have a complaint, you're going to be alleging your common law grounds, if you have them, and your statutory grounds, if you have them. We're going to talk about the differences. Again, some people consider publicity to be a privacy statute. They consider this to be privacy rights. In other words, the right to be left alone, the right not to have your face blasted on a bunch of photos or whatnot, not to have your voiceover used on the internet or on TV in a commercial, over the radio, somebody trying to publicize and make money off of your identity, basically. So in California, you have two different theories that you can pursue, or you can pursue both, okay? And so as a plaintiff in a case or a defendant responding to a lawsuit, you may see both of these alleged in the complaint, okay? So, but let's talk first about the common law. That is your judge-made law. That's the law that comes from the courts. Courts having problems brought to them over time, a body of case law evolves. This is your common law, what we call right of publicity. Some call it the appropriation, misappropriation, sort of like a privacy right, like, a property right, like you have an actual property value in your identity. And you can find the jury instructions if you're curious. That's CACI 1803. That'll take you to the jury instructions. So bookmark that if you're looking for the actual instructions. These are going to be sort of, easier to digest, easier to understand. I'm going to try to explain the elements to you. Now, when I say elements, bear in mind that the plaintiff has to allege, we've talked about this in other videos about complaints, the plaintiff has to allege these items and has to prove these items. Okay, so the plaintiff alleges and proves, the defendant has to raise their defenses. If they have defenses, they raise them. Okay, so the common law, under the common law, the elements that must be shown. One, use of identity. Use of identity. Now this could be anything, and the best way I can phrase this is anything that conjures up in the minds of the viewer, the listener, somebody who would see the ad, hear the ad. It would conjure up the mental image of the plaintiff. So there were cases like, there was a Vanna White case where there was a robot, and the robot was flipping letters, and so they said, well, that's Vanna White. Somebody's trying to copy Vanna White. And so that would be an example of sort of identity, something that Vanna White had to, sort of created her own little niche in flipping letters, and so she had some identity rights in that kind of case. You also have things like voiceovers, There was one case, I think it was the Tom Waits case, where somebody wanted to use his voice. He said, "No, I'm not interested. Look, I want to be left alone, not my deal." And they went ahead and did a voiceover, a voice imitation rather, something that sounded like him. And so of course that raised a right of publicity case under the common law. And I think that resulted in, as far as I remember, like a $2 million punitive damage. So it was a pretty big one. But keep in mind, that's a celebrity, okay? So, you know, you're always thinking about juries and what's a jury going to think of this case. So you have the element one, use of the identity, name, image, likeness, voiceover. I think there was a case where there was the pitching stance of Don Newcomb was the pitching stance in sort of like an illustration. He said, "That's me. I'm the guy that does that stance." So that was another type of case. But identity, use of identity, okay? And these are going to be the unconsented use. We'll talk about it in a second, but consent is going to be a defense to a misappropriation claim. So, but you have identity, use of identity, a commercial benefit or some other advantage, some type of advantage to the defendant. Need to be arguing about that. These uses have to cause damages. Don't forget, causation's always an issue. Did my use actually cause the damage you're talking about? Is there that nexus between the two? Harm, you have to have some kind of harm. California Civil Code section 3333, easy one to remember, quadruple 3, says any foreseeable detriment, foreseeable or unforeseeable detriment that this use cause can be recovered, hurt feelings, money, profits, damages, stress, all kinds of things. So, but you have to bear in mind, you need to show some damages to make your prima facie case. And then a balancing act is done. Final element is a balancing act. What's that? Okay, so we live in an information society. We want to be able to use pictures and sort of be able to give the free flow of information. But what the courts are going to do under the common law is balance the privacy interests of the plaintiff versus sort of maybe legitimate, when I say legitimate, sort of First Amendment, First Amendment, freedom of the press, freedom of speech, freedom of expression. So kind of balance it. If there's something that really tips high in the public favor, like, wow, this is a really newsworthy event, everybody should have to hear about, and we have his or her face and face, body, something, voice, and it's really an important thing, you may lose on that as a plaintiff. So bear in mind there's a little element of balancing act on this one, okay? Attorney fees, no attorney fees under the common law. No knowing use is required under the common law. No knowing use. So that means, if the plaintiff or the defendant says, "Oh, yeah, I didn't mean to. It was an accident. I wasn't thinking. One of my employees did it. I didn't know. I didn't know." That's probably not going to win the day, okay? So that's your common law. It's a separate cause of action. That's what you're going to allege in your complaint. A violation of the right of publicity under California common law. Boom, 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 boom. Hit your elements, throw them out there. Statute. You're going to now, the other side of the coin is the statute, which came later. The statute did not codify the law. It did not embody the common law and put it into a written statute. What it did, rather, was a separate statute that is basically complementing. Let's just say it's complementing the common law. You can find your jury instructions on this, 1804A, that's CACI 1804A. If you want to pull those up, take a look at them. Some good information there. This one requires a couple additional elements, so you're going to want to be thinking about these when you're pleading your case, okay? You need a knowing use. Remember we said here you didn't need a knowing use? Now you do, okay? We got to have that knowing use, intentional, using that intentionally. This one, instead of your whole identity, which is kind of a broad concept, this is limited. This is limited to actual name. This is name, voice, signature, picture, likeness. Name, voice, signature, picture, likeness. NVSPL. If you can remember that, you can get it for you bar exam takers over there. This may pop up. It's kind of a fun topic to test on, see if you know it. NVSPL. It has to be one of these. Now, and it's the actual, for example, under the voice, if somebody has a makeover, somebody's doing a voice imitation, that's not actually your voice, that's a sound-alike. So that would fall under here, under the common law, because that would be referring to more of the identity, okay? So it comes back to your identity. So bear in mind on these, you're going to need the actual name, the actual voice, the signature of the plaintiff, the defendants, their photo, using their photo, or some good faith argument as to the likeness being used. So it's more limited, not considered to be as broad as the common law would be. Here you need a commercial sales and advertising use, sales or advertising use. So you want some kind of commercial use instead of some, trivial use on somebody's Facebook personal page, let's say, on a Facebook personal page. So commercial, in business, on the goods, on the product, in the advertisement, something really where you can point your fingers at that, okay? Again, one of the things the plaintiff has to allege, which is different from here, but sort of relates to this, if you look at it, the Balancing Act that we talked about, no news, public affairs, broadcasting, political. So you have to allege that it's not for a legitimate, public use, not a legitimate First Amendment issue, political issue, sports broadcasting, those kinds of things. So those things, again, is going to go back to the free flow of information, First Amendment, legitimate public purposes. And if you have these, you may get to a point where there is a separate jury instruction where you have to show what we call the New York Times versus Sullivan standard. We're going to do another blog on that for you, New York Times versus Sullivan, where you have to basically show a very high level of defamation. You really have to show some willful knowledge or disregarding, or you know what you're publishing isn't true, in other words. Okay, so we're going to do another video on that. That's New York Times v. Sullivan. Check that one out if you're interested. You also have to allege lack of consent, same as this. Use of your name, voice, boom, boom, was directly connected. Okay, this is a little different. You don't see this over here, but you see it here. Use of the name, image, voice, likeness was directly connected to the commercial purpose. So in your case, think about it. Was this use, was it directly connected to the commercial purpose? Okay. Finally, again, substantial factor in causing, back to our causation, that's the same. In causing harm, once again, you want to show that harm, lost profits here. You'll seek attorney fees under the statute here. Bear in mind that the attorney fees is two-way, goes to the prevailing party. So if a plaintiff sues and loses, that's going to go to the defendant, and plaintiff could end up paying defendant's attorney fees. Bear that in mind. Remedies are cumulative. That means the remedies under this statute, if you have another statute that applies, another law or something, you have some other element of damage, some other statute allows you to get different kinds of damages, you can go for that. Maybe there's a financial elder abuse law that would allow you to double damages, or some law that would allow you to treble damages. Go ahead and look to treble those damages, okay? And finally, 3294, that is California's punitive damage statute. So if you can show malicious, oppressive, fraudulent behavior, you can come seek your damages for that. So we have another video on punitive damages, okay? But that's section 3294 of the Civil Code. That cannot be arising out of contract, okay? 3294. So there it is. You have your common law. You have your statutory, section 3344. You know where to find your jury instructions. You know the elements you're going to want to plead. Let's close it out with defenses. Possible defenses. There's others. These are some things to think about. First Amendment. We talked about that here. Here, be thinking, freedom of speech, freedom of expression, freedom of the press, those kinds of things. Consent. Obviously, if you're not proving your consent, the defendant should be saying, well, wait a second, he consented, there's a waiver, or she signed this model release form right here, look. So you have consent, you have parody. If somebody's doing a parody, that's going to relate to free speech. Parody being a form of free speech, also sort of one of the elements of a fair use. Okay, fair use, if you've heard of the fair use defense. We have a video on the fair use defense. Waiver, if you waive your rights, of course you can't claim. If you sign some waiver, you're released, or you saw them, you let them do it, you acknowledge it, and then you get all upset, and they may say that's a waiver, or some sort of estoppel may also pop up. Statute of limitations, generally speaking, 2 years. If the plaintiff waits too long, waits beyond 2 years, Could find some problems there, so you got a 2-year. Keep an eye on that. Remember, there's tolling and different things that sometimes may apply, so don't hold me fast to that. Check with your right of publicity lawyer. Review your case, see all your circumstances, see what you got going there. And then copyright preemption. If you're bringing a case that is too close to copyright law, it really looks like a copyright infringement case, of course, those are federal laws. Those go to the federal courts, and that would preempt your state law claims, because this baby is state law, common law, and statute law. Okay, so does that make sense? There it is, California right of publicity law explained by yours truly, Attorney Steve. If you have a publicity question, you want more information on this topic, go to publicitylawyers.com. I've got a lot of information there. I got the code sections, I got the statutes. I mean, I give you everything. You have it all. You have it all. So I hope this has been helpful. Attorney Steve Vondred, licensed practice law in Calfiornia, Arizona. If you have need some help with a publicity claim, give us a call. We're happy to help. Publicitylawyers.com will get you there. Feel free to share this video on your social media networks. And thank you for listening. I went through that kind of quick, a lot of information. Pause this video and go back and look if you need to get it, but I hope that's helped you out. Thanks.